What's up, everybody? And an attempt to continue to stay up to date on stuff that's going on in the other cases we've been discussing on this channel before the Murdoch trial, that never ending trial started. I wanted to just jump in and talk kind of quickly about the defamation lawsuit that was filed by Professor Schofield in Idaho against the TikToker who said that she basically solved the murders and that this professor was the guilty party who either committed these murders or ordered them to be committed. So we're going to break down what's going on in that case and if the TikToker has already lost during this video. So if you're still interested in this specific part of the Idaho case, I know a lot of you are still involved in and interested in the Koberger part, and we will continue to follow that absolutely. But these are kind of the things that can spin off when media gets involved and the case grows and people try to grab the attention and take things a little too far. And in this world, since Johnny Depp, a post Johnny Depp and Amber Heard world where defamation and what you say and what your lawyers say publicly seems to be more in litigation and in the court system than ever before, literally. So we're going to talk about that and more today. And if you're interested in it, hit the like button, subscribe to our page, and let me know in the comments whatever questions you have about this case. So we talked about the defamation lawsuit when it was filed, I think back in December. And there is a time period, I believe it's 21 days to, it's a federal case, I'm pretty sure. So 21 days to respond to the complaint, which put that response somewhere in late January. I think it was around January 19th. The defendant, TikToker, did not respond to the complaint in that time. So what happens? Well, you get a default, which means you win as the plaintiff. And so the plaintiff files a motion and the clerk enters a default at the end of January against the defendant, TikToker. She just did nothing and you can't do nothing. Now, today's video is going to focus a lot on default judgments, what they mean, what they should mean, whether or not they have teeth, how you can get out of them, how you prove once you win the default, how do you prove what the damages are and how much that person now has to pay you, and how do you go about collecting that money. Well, on February 16th, the defendant TikToker filed her answer and counterclaims, of course. If you sue me, I'm going to sue you, and not just you, but also your lawyers. That usually doesn't work ever. You can't just sue somebody for suing you, right? But you can countersue for defamation against the other party if you feel you have a legitimate claim, a la Amber Heard, and the counterclaim of I defamed you, you defamed me. The TikToker tried that, plus suing the lawyers, which Amber Heard used some of the lawyer statements as well. So did this TikToker go to the Amber Heard School of Law in drafting her own response pro se? I will say no. If we are going to compare it to a different defendant's school of law, it is much closer to the Darrell Brooks School of Law than it is the Amber Heard School of Law, because she denies that Schofield is an individual and there are some other weird things in there. There's comparative negligence, which makes no sense. There's all sorts of statements that she makes throughout her answer, affirmative defenses and counterclaims, that make absolutely no sense. She also doubles down and triples down on the defamatory language, accusing Schofield of being involved in the Idaho killings again and again, and how she is right about this stuff. Not great to also put it in a court document, but as we know, it's already all public on TikTok, so why not? It seems like she is going to get convicted, or not convicted, but she is potentially going to lose based on her own statements, which we always say, if the defendant has their own words used against them, that is, in fact, the best evidence. And we see how much social media is being used in trials today. That is absolutely going to be part of this case if she hasn't already lost, because the clerk has entered their default prior to her answer and affirmative defenses, which she just ignored the default and filed this answer. This answer will not be considered by the court because of that entry of default. I will say, if you read through this answer and counterclaim, which I didn't want to, it's like 20 pages long, it seems like she had help. And I'd be willing to bet she had help. Maybe somebody that believes her, somebody that's kind of in her world or in her space, helped her draft this, that has some kind of legal knowledge. Maybe she talked to Darrell Brooks. I don't know. He's got experience now as a lawyer. He's tried a case. That's more trials than a lot of lawyers have. And he's going to get more trials, it seems like. But that's neither here nor there. Seems like she had help. she did draft things appropriately. She did put some case law in there. She did have some statute numbers in there. So I do think she had a little help, maybe did a little research on her own. But usually what you need to do is file a motion to set aside that default. And this happens from time to time in our cases. And I'll explain that nuance in a little bit. Well, she did end up, after filing this answer and counterclaim and affirmative defenses, she did file a motion to set aside that default, and we will see what the court does there. Now, when I say you win when you get this entry of default, technically that's what it means, but I will tell you, the vast majority of the time, when it is a couple weeks late like this and good cause is shown, the court will set aside that default. So while it seems like she's lost the case, I'd be willing to bet at this time the court is going to set aside that default and allow her to defend the case. While a lot of what she said in her court filings were hogwash, I do think excusable neglect and in the interest of justice, let her defend herself. She doesn't have a lawyer. It is pro se. It seems like she's got some other lawsuits going on. She has PTSD as a war veteran. She is a single mom. A lot of extenuating circumstances. I will just say in my experience and in this jurisdiction, the courts have set aside defaults for much, much less than that. They've also set aside defaults that we have had against humongous multi-billion-dollar insurance companies who have lawyers that they literally have on salary in-house and pay millions of dollars to lawyers and experts every year. They miss responding to complaints sometimes, and the court will set aside those defaults and still allow them to litigate and defend the case. I would expect this court to set aside the default unless they feel like there is some nefarious actions going on in the background. And Schofield's attorney's response is actually really interesting and could set this in the small minority of cases where the court would say, no, we are going to leave this default in place. So we'll get there as we get there in the process. So like I said, her counterclaim had a lot to do with defamation, including the lawyers, and much ado about nothing for the most part after that. So she did then file the appropriate motion to set aside default, at least enough to have a court look at it and make a decision, potentially have the court hold a hearing by Zoom. One of the issues is this even the proper venue and jurisdiction for this case, or should it be where the TikToker lives? That's something that may be discussed in the future if she hasn't already lost the case. But I will tell you, that's also another reason for the court to set aside this default. This is not where she lives. This is not what she knows. This is an outside jurisdiction and venue to her. Makes the entire process harder. It is federal court. She is an individual pro se. It's a civil case. You don't get a lawyer appointed to you. So if you can't afford one, you do have to do it on your own. The court is way more lenient on these rules and timelines on pro se defendants than they are on attorneys or big insurance companies, and they still set aside defaults all the time in those cases. All right, so let's get to Schofield's attorney's response to the TikToker's motion to set aside the default and answer counterclaims, all that stuff that was untimely. So while they understand that many times the rules can have some leniency to them, in this scenario, they think it is totally unfair to allow her to continue to delay this process. It's costing the Idaho professor time and money. It's gaining exposure for the TikToker. She's profiting off of this literally. And not only was this not just a 20 or 30 day delay or a couple week delay outside the time period to answer the complaint, she is complaining about, she wasn't served properly. She knew that this complaint was coming based off multiple cease and desist letters where she went on TikTok and talked about them and talked about receiving them and talked about how she was going to ignore them. She received this complaint and did nothing about it. And basically her TikTok can confirm that. So we will see her TikTok and her videos used against her yet again and in this process. And this is the type of situation that the court may look at. I would be very surprised, and it would be in the small minority of cases that they actually ratify this default and say you lose based on this time period of just a couple weeks. Now, I wish they would, and I wish everybody was strictly held to the rules. But unfortunately, that's just not how it works in our legal system. Let me know in the comments if you agree or disagree with that. Where should the leniency be? What is the point of the rules, right? We don't say you have to respond to a complaint in one day. We give you the leniency of 20, 30, whatever days, extensions if you ask for it, depending on what document is filed. But what's the point of having a rule if we're not going to hold people to it? I'll get off my soapbox there. But let me know what you think, if they should be strictly adhered to. So they say that this was done in bad faith. She's continuing to try to delay. She knew this was coming. She knew she was served. She knew the lawsuit was filed. She still did nothing about it. She didn't file the proper documents in order. And so this case should be over. And if it is over, just because you won the case, you do not automatically get a specific amount of money in a civil case. You have to prove your damages. Unless, and we've done this at times. And I would have said if these lawyers would have talked to me, and again, this may sound, there's no reason for them to talk to me. I'm just saying, if these lawyers would have talked to me in a case like this, where she was ignoring you, you sent cease and desist letters, she was posting videos saying she was ignoring you, something you can do is put the actual dollar amount in the complaint. Because many times those paragraphs are deemed admitted when they're not answered, and you get a default, and that can be evidence that those are your damages in this case. Now, most of the time you don't put the actual damages amount. You say the damages exceed whatever the jurisdictional amount is. We've seen that in other cases, 50,000, 30,000, 100,000, whatever it may be, 75,000. And then you can prove above that, right? But if you want a specific number, you can put a specific number in certain circumstances, and it may be deemed as an admitted fact. Now, we've done that in cases, and sometimes it's worked. We've done it in cases, and sometimes the judge still wants proof of those damages, which is within the judge's discretion. So it's not a end all be all. So what do? Well, they file a motion for entry of judgment to the tune of $1.8 million in damages. They don't explain how they get to that number in the motion for entry of default. But what usually will happen after that is there will be some kind of hearing where the attorneys for Schofield, the Idaho professor, will go before the court, make their argument with documents, affidavits, whatever proof or evidence they have of these damages without the involvement of the defendant, because the defendant never gave them discovery. So whatever they have that can prove these damages, they will go before the court, make their arguments, and the court, not a jury, but the court will determine what the default judgment amount and damages should be. And without the other side arguing, usually you got a pretty good chance of winning, right? Nobody arguing against you, just a judge who realizes the other party's not doing what they should do, not even participating in this scenario. Now, another scenario, even if the court enters default, the defendant can still be heard at the damages hearing in this entry for the default judgment. Just because they didn't do anything in the case and they lost doesn't preclude them in most scenarios from coming and making arguments. So if she wants to, she can say she actually wasn't damaged at all. Here's affidavits and evidence on my side that shows the damages should be $1 or something like that. And they can make those arguments. And then the judge would have to weigh what two sides are arguing and come up with whatever the decision they think is fair as the court. Now, what happens after you get a default judgment? You get the entry for the amount you want of $1.8 million. Does that mean then, boom, stroke a check right now, defendant? Oh, no. Most defendants are not collectible, especially individual defendants. They either have protected assets, hidden assets, or no assets at all. Most of the time, they don't have insurance for defamation, as we talked about, and Amber Heard was the exception to that. But most of the time, my guess is this TikToker does not have insurance for this defamation. Now, I could be wrong about that. It's just a guess. And so what you have to do is everything you can to try to collect $1. Liz Pendants on some unprotected property. I think she's in Texas, which has very big time homestead protections and shields a lot of this from being taken. Now in federal court, sometimes you can do a little bit more, but it will be very hard to collect this amount of money. So even if you win by default, you get the entry of the default, the judge gives you the damages you want. Passing all those hurdles sometimes can give you a piece of paper that says you are owed $1.8 million and nobody ever pays it. Now, that may be all this professor wants, and she wants it to go away, and maybe she wants some specific performance for the judge to instruct the TikToker to not speak her name anymore in this way or at all. Who knows? We will see. But very interesting, just a legal procedure that's going on right now with filing the complaint, failing to answer in a timely manner, entry of default, trying to get the amount of damages awarded from the judge, and now the defendant coming into play in the process. Will they set aside that entry of default? Will the TikToker lose before she even gets started? A lot of open questions still on this case. So let me know if you're interested and let me know what you think about it in the comments below. Thanks for joining us as always. And please subscribe, because I want to know, what do you all want to hear about content-wise? Murdoch is over. Sarah Boone is coming. We have some time here to catch up on some other cases and maybe even look into some new cases. So I want to know what those new cases are you're interested in. Follow me on Twitter. I almost said TikTok. I do have a TikTok. On Twitter and Instagram at Tragos Law, and we can continue to discuss this in the DMs and in the tweets. Thanks for joining. I'm out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok at Tragos Law is our handle. And don't forget to listen to the Lawyer You Know podcast featuring new episodes every week. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, the Lawyer You Know.